Welcome to Give Smart, the video series where we break down the legal side of giving. I'm Isabella, and in each episode, we talk to experts who help companies and nonprofits navigate the complex but important world of compliance and charitable fundraising. Today's episode is all about charitable solicitation laws, what they are, how to navigate them, and what businesses need to do to stay compliant when they give back. I'm joined today by Nathan Thomas, a partner at Copilevitz, Lam Raney, who works with both companies and nonprofits on charitable fundraising and compliance. Nathan, thanks for being here.
Happy to be here. Thanks for having me.
To kick things off, can you introduce yourself and share a bit about your background and the kind of work you do at Copilevitz, Lam Raney?
Sure. We are a law firm in Kansas City called Copilevitz, Lam Raney, and I'm a partner here. And our practice primarily focuses on charitable fundraising compliance. We have about, 1,500 tax-exempt charitable organization clients nationwide, but we also represent for-profit companies that engage in fundraising and those companies that might have charitable sales promotions, which I think we'll talk about during this broadcast.
I'd love to start with some definitions just to kind of ground the conversation. What exactly is a commercial co-venture and what is a professional fundraiser, and how do those two things differ?
Sure. To give a little background, there are about 38 states that require charitable organizations to register in order to solicit contributions. Whether or not some charity engages in telefundraising or has a gala in person within a state, prior to making those solicitations for money, they have to register. Typically, the registration is with the Secretary of State's office or the Attorney General's office, or some state agency where the charities regulator is housed. And not only do charitable organizations have to register, but there are particular fundraising vendors that charities hire from time to time that also have to register. And that's where these commercial co-ventures and professional fundraisers come into play. A professional fundraiser is typically a company that provides fundraising services for a charity. They might be the telefundraising company that calls you at home and asks you for money on behalf of a particular charity, or they might be a company that specializes in, speaking with high net worth individuals that might support your cause, and they're paid for soliciting on behalf of the charity's behalf. And so there are about 45 states that require these professional fundraising vendors to register in order to act as such vendors on behalf of charities. The difference between a professional fundraiser and a commercial co-venture is that a commercial co-venture is not in the business of fundraising like a professional fundraiser is, but they're typically selling some good or service with the representation that the purchase of their good or service will result in some contribution to a charitable organization. So for example, if company X sells tennis shoes and they say, for every pair of tennis shoes I sell in October, we'll give $1 to X charity, then that would be a charitable sales promotion, and the donating company would be called a commercial co-venture. The good news is, for those for-profit benevolent companies that engage in these promotions, there are only a handful of states that require registration, and the registration isn't very burdensome. There's only, 3 or 4 states that require that registration. The primary compliance issue related to those promotions are the point of sale disclosures, making sure the public is aware of what will be donated and what triggers that donation. So in my example, then it would be clear to the consumer which charity receives the $1 as a result of the purchase of the tennis shoes. And so that's important to disclose. There should also be a written agreement between the commercial co-venture and the charitable organization, whereby the charitable organization is authorizing the use of its name and or logo, if it's the case, in conjunction with the promotion. And then those contracts also have certain specific language in them under the state commercial co-venture laws. Registration and bonding requirements at the state level for professional fundraisers is much more onerous than it is for commercial co-ventures. Like I said before, there's 45 states that require fundraisers to register, and a majority of those states will require the professional fundraiser to get bonds. Now, the purpose of these bonds, which have to be filed with these fundraiser registrations, is so that if the fundraiser somehow, in the unlikely event, engaged in fraud and ran off with the charity's money, or engaged in some type of misrepresentation, then I suppose the state and or the charity left holding the bag could call in the bonds, and then there would be some relief to the charity. In 30 years or so, I think our firm has seen maybe one or two of those bonds actually called in, which begs the question, are they really necessary? You just don't typically see them called in, and they are a significant expenditure burden for those company vendors that apply for them and get them, especially for new platform fundraising companies, which might not have the capital to even get the bonds and might have to personally guarantee them. On the commercial co-venture side, there's only Alabama and Massachusetts of the 3 or 4 states that require registration that actually require bonds. So the hurdle is much easier to overcome when it comes to getting those bonds. I don't typically hear many complaints about that, although those are also rarely, if ever, called in. So
interesting. Wow. In 30 years, just one time, that's kind of crazy. Let's say you're an online storefront selling t-shirts in all 50 states nationwide, and you want to donate $10 per t-shirt to X charity. Can you walk us through briefly what a compliant CCV campaign would look like in this case?
Sure. The one thing that I emphasize to my company clients that want to engage in these type of charitable sales promotions is to first do some due diligence to check and make sure that the beneficiary charity, the charity that's going to receive money as a result of the promotion from the company, is registered to solicit contributions with the states. In the event a charity is going to be benefiting from a charitable sales promotion, the expectation of the charity regulators is that the charity is registered to solicit in any state where the promotion is offered and or advertised. So if you have a national campaign whereby the company is saying we're going to donate $10 for every t-shirt sold, then the company should first do due diligence to make sure the charity is registered nationwide to solicit contributions in order that their name and logo can be used in conjunction with the promotion. There's 2 reasons for that. Number 1, the obvious reason to comply with state law. Number 2, the commercial co-venture is unable to fulfill its own registration and contract filing obligations with the state regulators if the charity is not registered. As an example, in those states where they have to register and file the contract, Massachusetts is an example. If they file the contract in Massachusetts and the regulator will cross-check to see if the charity is registered in Massachusetts and they're not, then they'll kick back the contract and say, you can't engage in the promotion related to our state.
Have you found in your experience that it's common for charities not to be registered?
The charity regulators do such a good job and have over the years of public education, whether it's through their state agency, education department, or the department heads if it's the AG or the Secretary of State. But there's a lot of information out there. From time to time, rarely you'll see charities that are unaware of the situation, but they're usually smaller organizations, maybe single state or regional.
Gotcha. Okay, that makes sense. I guess that's encouraging news for companies that want to engage in these kinds of charitable sales promotions. That won't typically be a hurdle in most cases. It shouldn't
be difficult for them to find if there's a particular charitable purpose area, whether it's environmental or helping the poor or whatever it might be. It's usually not difficult for a company that wants to engage in one of these promotions to find a entity that furthers the cause they want to support and that is registered and compliant.
What are some of the most common legal requirements that companies may overlook when launching a commercial co-venture?
Well, funny enough, what we mentioned, I do run into situations where the marketing team at a company is all the way down the road on a charity that they wish to support. They may have already drafted all the copy and content for an advertisement related to the promotion, and maybe in some situations spend a lot of money, and then come to find out it's like we discussed, a smaller charity that they wish to support that may be only registered in the state they're located in, which presents a difficult question for the company at that point, which is, do we try to find another organization that's registered nationwide and try to change all of our advertisements and copy related to the promotion? Do we want to try to help this organization get registered and then thus have to postpone the charitable sales promotion? Or do we decide to take the risk and just go for it and cross our fingers that we don't get in trouble, which obviously we would not advise. But it does create issues, and it's one of the reasons why it's important for companies to understand that anytime you are contemplating using your company name or good or service that you provide in conjunction with a charitable purpose or charitable organization that, we look to see if we need to comply with commercial coverture laws, if they're applicable, and make sure the charity is maintaining its own compliance obligations.
I'd love to talk a bit about California AB 488. This law has really changed the game for online charitable fundraising, as you know. What should companies know about it? How does it affect things like roundup campaigns or platforms that help facilitate donations?
The new California law has created a number of challenges. In fact, I complained to my colleagues and private practitioners that I'm spending 70, 80% of my time on the new law when it's one state out of 50. And the reason that is because it's codified some language that is totally new. We talked about professional fundraiser compliance and registration, but California has created a new category called charitable fundraising platforms, which requires charitable fundraising platforms that are processing donations from California, or they're located in California, or they're accepting gifts from California, and possibly if they're paying out money to a charity in California, they're requiring these platforms to register if they enable any act of solicitation, or there's any type of solicitation or solicitation processing on the platform itself, which is very broad and creates a number of issues. And so it's a relatively new law. We haven't seen any enforcement yet, so the guidance is we're still waiting on it. The primary issue that I'm running into is related to one of the provisions in the new law, which disallows the platforms to solicit or enable the solicitations or to pay out to charitable organizations that are not in good standing under the law. And with respect to what that means, good standing means, your 501c3 status hasn't been revoked, your charitable registration is in good standing with the California Charitable Registry, and that you are in good standing with the California Franchise Tax Board. Now that's all in good. The problem we're running into is that I've run into situations numerous times where the charitable organization has filed its renewal and it has not yet been processed by the state. The state currently indicates to my paralegals that they take sometimes upward of 90 days to process the registrations. And so, and they also issue deficiencies from time to time, which may be ministerial or administrative in nature, or somebody, forgot something in their package that's that they needed to provide, or maybe they got the filing fee wrong. And the problem you run into is that those registrations will become deficient, and because the state doesn't have the administrative numbers or efficiency to process these within a reasonable period of time, then some of these charities are not in good standing. And as soon as they are not in good standing, these fundraising platforms will cut them off from their ability to receive or process or solicit funds on their platforms, which is a major issue. Now, I'm talking about major platforms that are doing this and are complying with the law, and I'm also talking about major national charitable organizations that are reputable and have filed in California and nationally for many years that are facing this issue. And to try to emphasize how important this issue is, I'm getting emails daily and calls daily related to it. It's a huge problem. I hope the state understands and appreciates the problem. I think that their office has also been inundated with these calls. At least my clients are telling me they've tried to contact California, but it's really disappointing and it's frustrating because I've also seen situations where companies are unable to just shut off California. So it's not a function of saying we're just going to stop processing donations from California because the charity's not in good standing there. A lot of times the companies are saying, from a practical perspective, they're not able to do that, and they have to shut off the charity from all nationwide solicitations and processing, which puts the charity at a significant disadvantage from raising funds, even though the registration renewal may be sitting on the state's desk for 90 days. Now, we've proposed fixes to the state. In fact, I think some of my colleagues have even made suggestions recently. One that I thought of a couple weeks ago was there are a number of state laws, and notably in Pennsylvania and New Jersey, whereby the state is required to process these registrations within 10 days or 15 days. And if the state is unable to do that, then the registration is thus deemed approved. So that those timelines were put into those laws to protect against those prior restraints. And unfortunately, California doesn't have any of that language in its law. But I think, amending their statute accordingly would fix this problem. So if the state was sitting on a registration renewal for 90 days, and the law said it was deemed approved within 15 days, I think a lot of these problems go away that we're seeing on these platforms. Other of the platform language is consumer protective, and I think is good with respect to fee disclosures and things like that. But some of this impractical administrative processing lag is a real problem in creating major issues for the fundraising community, and it's a hot topic that needs to be addressed.
I've heard rumblings of other states potentially adopting similar sorts of provisions or like legislation similar to CA AB 488. Are you concerned, or do you have any thoughts around other states adopting similar requirements?
Yeah, Hawaii has adopted similar legislation to California. Some of it's similar, some of it's different. That doesn't go into effect until, I believe, 2026. We're still reviewing that, and we're trying to submit comments related to that law to try to avoid some of the problems that we're facing in California. But I don't know of any other states that are looking at drafting similar legislation. I would be surprised, though, if this is like a domino effect. I think this is going to be more the minority of states, similar to the commercial co-venture registration requirement. It's going to be a few, but not many.
On a related note, are there any new or growing challenges companies should be aware of when it comes to fundraising laws?
Well, I guess one of the things to keep in mind is related to the Roundup campaign. A Roundup campaign historically typically does not fall under commercial co-venture laws unless you look at some of the broader commercial co-venture definitions. But now, with the charitable fundraising platform law in California, if you have a company, for example, and we're all familiar with the grocery store example where you go to the grocery store and you pay for your items. They say, Nathan, would you like to add $5 to your purchase to make a contribution to X charity? Then if you're doing that online, you're now subject to your charitable fundraising platform registration and laws in California, because you're soliciting on a platform, which to me is a problem, because I've actually seen companies in my practice that are deciding not to do it, just too much of a pain. At the end of the day, you're looking at a situation where it's a part of their goodwill and marketing. They're exposing charities to a large number of consumers that wouldn't have otherwise known the charity existed. And so that's creating a number of issues too, and kind of averting some companies from doing it.
Interesting. In those cases where a company wants to do a Roundup campaign, but then they find that it's too burdensome because of the charitable fundraising platform requirement, do you ever advise them to do a different sort of CCV campaign, or like a different, I don't know how you talk about it, but like a different mechanism?
They can either disregard and get rid of it altogether. They can geofence California from the Roundup campaign altogether, or they can bite the bullet and make the filings and disclosures as required under the law. It's really up to the client, but there's been more apprehension that I've seen because of the new law and its application to the Roundup campaigns. The other problem you run into is another part of the California law, which in the event the recipient charity is no longer in good standing in California, and you've run one of these campaigns and you're looking at it after the fact, what happens if the charity then is no longer in good standing? Is the company allowed to pay the money to the charity? Well, in California, one of the requirements under the regs is to contact each particular donor, even though they may have given 1 penny to the charity out of the Roundup dollar, to go back to the donor and say, oh, well, they're not in good standing. Who else should we give it to? And then have to check and see if that charity is in good standing. Now, from a practical perspective, that makes no sense. And it could be 1 million people that have engaged in the Roundup. And so you're going back, how does that really work, from a practical perspective? That's another thing that's creating a number of confusion and issues, and one of the reasons why some of the companies are a little apprehensive in doing those programs now, in my experience.
I have one last question before we wrap up. For a company's first cause marketing or CCV campaign, what advice would you give their legal or marketing teams to make sure things go smoothly?
Well, a lot of times for our clients, we like to do where we sit down with the client and go over with their marketing team and their legal team at the same time, see what type of promotions they're interested in running. And then we go through the compliance measures related to the particular promotions they want to run, whether or not they're charitable sales promotions or they trigger the new California platform law, making sure that we're giving to compliant charities and doing due diligence on them. So it's a process, but getting it addressed at the beginning, I think, is helpful, and educating them on how it works and why we want to do it and the consumer protection issues and why it's important. So those things, I think, are good to start off with.
Cool. Do you find that the marketing and legal alignment is really important at the start of these sorts of campaigns?
Yeah, absolutely. I mean, the marketing folks usually are not always happy with, the legal disclosures that are necessary or what we want to do, or they're too verbose or too much language. But it's important to make the disclosures that are required by law. And so you don't violate those laws, and so you don't trigger consumer complaints. Some of them are a little confusing. In my mind, it's better to have simple promotions that are understandable. If they're too complicated, it often triggers regulator inquiry or consumer complaints. And frankly, simpler is better in my mind. So.
Yeah, for sure. I work in marketing, so I definitely sympathize with the marketing side of things. But having worked here, I also understand, the legal side is
Sure.
very, very important. So. Cool. Well, thank you so much, Nathan. This has been really helpful, and I really appreciate your expertise. Thanks for walking us through everything today.
All right, you too. Take care.
Thank you all for watching. If you're planning a charitable campaign or supporting nonprofits through your business, be sure to follow our Give Smart video series for more insights on staying compliant while making an impact. See you next time.